Hello and good afternoon to everyone. Glad you could join us. I'm Phil Brink. I'm the consulting coordinator of Colorado Cattlemen's Ag Water Network. We also have Sarah Didrikson here in the background. She's with Colorado Cattlemen's as well, and she makes this webinar go smoothly. Today, we are going to be talking with attorney David Kueter about water right abandonment. And our water law in Colorado has been appropriately summed up as use it or lose it. And the losing it part goes to water right abandonment. Every 10 years, Colorado's Division of Water Resources publishes its list of abandoned water rights. And then it is up to the water right owners to prove that their water right is still being used and has not, in fact, being abandoned. So we're going to talk about that today. David has been practicing law for over 25 years. He focuses on water law and water quality, real estate, and land conservation. He has participated in litigation in state and federal courts, including water court, appeals to the Colorado Supreme Court, and regulatory and administrative proceedings before state and federal agencies. He has also presented workshops and educational lectures on water law and the interpretation of water and land, or pardon, the intersection of water and land conservation. He joined the Holsinger Law Firm in 2018. Before we begin, if you have any questions, while David is presenting, if you could just hold those, you can put those in the chat, but don't verbalize them. Just put them in the chat if you would. And then when we're done, in whatever you are comfortable with, you can either unmute and ask your question when David's finished presenting, or you can just put that in the chat and I'll cover it for you. Today's webinar is being recorded, and it will be posted on our website at agwaternetwork.org, along with highlights of the webinar. So, David, it looks like we've got a pretty good crowd here. There's a fair bit of interest, it looks like, in water rights. I suspect that's been your experience as well. It seems like in Colorado, water rights get more valuable and more important every single year. So, if you're ready to roll, go right ahead.
Thanks, Phil, and thanks to everybody joining us today. So it was just about 4 years ago that at the very start of the 2020 abandonment process that we held a similar workshop in person up in Craig. And as we get to, we're actually not quite at the end of the 2020 cycle, but as we approached the end of it, we thought it would be a good idea to touch base and both give some information as to maybe what we've learned in the past 4 years, but also turns out that 2030 is a lot closer than it used to be. So provide some information as to what steps to take and how to move forward to try to avoid having water rights show up on those 2030 lists.
Energy drink?
As Phil mentioned, water rights in Colorado are a usufructuary right. That's the $20 lawyer word for it's a right to use the water and not actually ownership of the water itself. And Phil mentioned the shorthand of use it or lose it. And so this is the statute that defines what abandonment of a water right is. It means the termination of a water right in whole or in part as a result of the intent of the owner thereof to discontinue permanently the use of all or part of the water available thereunder. I've highlighted a couple of the key points of that. Abandonment is termination of the water right. The water right no longer exists once it's found to have been abandoned. The water is abandoned to the stream, and in a priority system like Colorado has, the next person in line in terms of the next priority just gets to move up a step. And once that termination occurs, that water right cannot be revived. you can get back to the back of the line and file for a new water right at the same location, the same uses. But once abandonment has been found, that water right just entirely ceases to exist. Also, the statute makes clear that portions of water rights, not just the entire water right, can be abandoned if a portion of the water right is not being used. And we'll get into a little more detail as to the reasons why I think there were a lot more partial abandonments listed in the 2020 cycle. And then finally, the key point is that there has to be a finding that the owner intended to abandon the water right. But that is, as we'll see in the next slide, that's not just a subjective determination. So just saying you didn't intend to abandon the water right is not in and of itself enough to prevent that finding. So another statute here where failure for a period of 10 years or more to apply a water right to beneficial use creates a rebuttable presumption of abandonment of the water right, but the division engineer or state engineer can waive that presumption. And this is really the heart of use it or lose it. If you don't use your water right for 10 years, then the state is entitled to that presumption that you actually intended to abandon that water right. And we'll get into a little detail later that there are ways to rebut that particular presumption. Couple of other points to highlight here. It's applying the water available. So if there's a drought and there's just physically not water available in the stream, or it's all going to senior appropriators, that is not going to trigger this 10-year this presumption that non-use for 10 years means that there's intent to abandon. It's also whether the water right is needed. And so the reverse of the example I just gave is if we got 10 years of rain, which obviously is not a common occurrence in Colorado, but where there actually just wasn't need to divert the water for its beneficial use, then that also won't trigger that presumption. Although I would certainly caution that if you find that for a long extended period of time a particular water right is not needed for the beneficial use, then you are at least risking a finding that additional amount could be considered waste. And so that particular, I guess, exception is I would apply with caution. So there are a few statutory exemptions for that allow for periods of non-use without it leading to a finding of intent to abandon. The first is if the water right is used on land enrolled in a federal land conservation program. Also, there are multiple statutory Colorado statutory programs, water conservation programs, land following, water banking, loans or agreements with Colorado Water Conservation Board, where water users can agree not to use their water for a period of time specifically to accomplish the goals of these various programs. And the statute clearly provides that if you are not using your water right because you're participating in these particular programs, that's not going to lead to a finding of abandonment. And then just last May, we got a new exception, which is from January 2020 to December 2050, where an electric utility in Water Division 6 decreases or does not use a water right, that won't be, and the utility has owned the water right since January 2019, then that won't be lead to a finding of abandonment. Obviously, that's a very very specific and targeted exception. But if there are any electric utilities on the call here, you have a little bit of a get out of jail free card. As Phil said, under the statute, the division engineers in each of the 7 water divisions are required to prepare a list comprising all absolute water rights that they have determined have been abandoned in whole or in part over the prior 10 years. And the first year of that statute being effective was 1990. And so it's every 10 years on the 10s and 20s. And we just got through, as mentioned earlier, the 2020, or we're getting close to the end of the 2020 process. So this is the schedule for how the publication of that list, and then how it gets refined, and the opportunities for people to object or protest to the inclusion of water rights. Since we are through all the deadlines for the 2020 list, this is the schedule for the 2030 lists. So the first step is that the division engineers publish their initial proposed abandonment list. That's generally on available on the DWR website. They are also required by statute to send notices to the last known owner of the water right. But experience is that the Division of Water Resources records as to ownership have not always been comprehensive. So as a water right owner, I would not rely on that notice being the only way to ensure whether my water right has actually appeared on the list. And then again, in July through August of that year that the lists come out, they get published in each county. So they should appear in the newspaper of record for the county. And then water right users have essentially a year until July 1st of in this case, 2031, to submit written statements of objection to the particular division engineer that for the list that they are objecting to. And for this last go around, the state actually prepared a form which you would be able to fill out and were actually requested to use in order to submit that statement of objection. And then by December of that same year, in this case 2031, the division engineers file revised lists with the water court. Those lists are published in the water court resume, and then by June 30 of, in this case 2032, is the deadline for filing written protests with the water court. And so the publication of the filing of the list in water court creates a water court case for the abandonment list. And then if there are protests of any particular water rights on the list, those protests get their own related bifurcated case that then is where that determination is made as to whether the listing was proper. And in 2018, the Supreme Court adopted a new rule under the Water Court Rules, Rule 12, which specifically deals with how these water court protests are handled. In large part, they're dealt with similar to a general water court case, but there are a few a few abandonment-specific provisions. One is that the party protesting the listing is actually responsible for the publication of that protest in the local newspaper, and including the cost of that publication. Also, a little contrary to normal water court is that the division engineer is considered the applicant, whereas the protesters are considered opposers for the purpose of the various procedural court rules. And then based on that publication, any person who may be affected by that specific protest may enter their appearance either in favor or opposed to a particular listing by, in this case, it would be August 31 of 2032. And then from there, the case proceeds generally similar to a water court application through the court process. So these are some very rough numbers from the 2020 process. In this, the dark blue line, those are the number of water rights listed on the abandonment list in 2010 that were filed with the water court, and these are separated out by the 7 water divisions. The orange is the number of water rights on the initial lists for each division that were published by the division engineers. The green is are the number of water rights that were included on the list that were filed with the water court in 2022. And then 3 of the divisions, Division 2, 5, and 7, have actually completed that water court process, and the final abandonment list for those divisions have been approved by the court. And so then for those 3 divisions, that lighter blue line shows the number of water rights that were actually included on the final list. And so a takeaway from this, we saw a pretty dramatic increase in the number of rights listed in Divisions 2, 3, and 6, although the Division 6 initial list was pared back down before it actually got filed with the water court in 2022. And big picture numbers, there were in 2010 there were about 2,700 water rights listed. In 2020, the initial list included about 4,400. And then the final lists that were submitted to the water court in 2022 statewide, there were about 3,400 water rights listed. So in that period between the initial publication and the submittal to the water court, pretty close to 1,000 water rights were actually removed from the list. Just personally, on behalf of various clients, I ended up submitting about 35 to 40 objections to the original list. Ended up with filing water court protests to 8 of those final listings, and all of those cases, with one exception, have been resolved. And I actually believe somebody involved in the one remaining case is actually on the call here today. So how do you ensure that your water rights aren't included on the abandonment list? And specifically, I'd be right now looking towards the 2030 list, which again is already frighteningly close. The easiest way is just to use the water. The Division of Water Resources between the 2010 and the 2020 lists actually digitized a lot of water right information about water right decrees and a lot of their diversion records. And so it was relatively straightforward for them to compare what was the highest diversion rate over the previous 10 years, and then what's the decreed amount. And some correspondence with the state during that 2020 process indicated that they felt that if there was a discrepancy between the highest listed diversion and the decreed amount, that they were legally obligated to include that unused portion on those 2020 abandonment lists. Another step to take is to make sure that structures are maintained and repaired and that measurement devices are in place. This requirement may get a little easier because just this past year, Water Division 6 enacted measurement and diversion structure requirements, and so complying with those measurement rules should help ensure that the use that any particular user is making of their water rights is accurately recorded at the division records, and that they're using those again, hopefully accurate and reliable diversion records when they are making the determination for the next list. Division 6 has those measurement rules in place. I believe I just saw that Division 7 is starting the process to adopt rules along the same lines. You should also just make sure that you are reporting your water use to the division engineer. And again, that just makes sure that the division engineers, when they are preparing the abandonment list, have the most current and the most accurate information. And all of this information is available on the division engineer or the Division of Water Resources website. And so my recommendation would be to check those records regularly, both to make sure that they are accurate, but also then you can identify whether there is some vulnerability for a particular water right to end up on the abandonment list. And so the next lists will come out in July of 2030, and I'm not sure I would expect the division engineers to have a lot of capacity to, if there is something wrong or some discrepancy in the records, they may not have a lot of capacity in 2030 to actually address that on a point-by-point basis. And so I would probably make sure that I was on top of that probably at least the year before, so that, again, that the division engineers are using the best quality information when they are making their determinations as to what to include on the list. So if you aren't able to actually use the water right to its full capacity, the Colorado Supreme Court has identified several specific types of action that can be justifications for not using water rights for a period of time. And none of these are exclusive. None of these are magic bullets. And so if you are unable to use your water rights for an extended period, the goal would be to check as many boxes as you can, again, because then you get into from kind of a math exercise of, are you diverting as much as you're decreed, to more of a narrative argument as that this is this is the type of demonstration of intent to maintain your water right that would overcome that rebuttable presumption. So one is to actually attempt to use the water right. And there we get into issues discussed earlier about, is there water available? Is there need for the water? The next one is that you're repairing or maintaining structures and ensuring that your structures actually are capable of diverting and using the entire water right is evidence. I guess might be easier to say the other way around, which is that if your tailgate or your ditch can only accommodate a portion of the water right, that's going to be some indication that you don't actually intend to use the entire right. And this would apply to all of these, but repair and maintenance of structures is an area where the recommendation is to keep records, and if you're spending money, keep statements and just keep as much documentary evidence as you can to, in case you end up in the water court case having to argue that despite non-use, you actually intended to continue to utilize the water right. Participation in water court, either in defense of the water right or with a water court application, such as a change of water rights or a change of use. All of that is pretty good evidence that you actually intend to make use of the full water right. On the next one, the courts have said that getting a water right removed from a prior abandonment list is evidence that you do not intend to abandon the water right. But one that the prime case that discussed that indicated that by itself probably isn't going to satisfy the overturning the presumption, and that's one that probably needs to be part of kind of a larger list of things that you are doing with the water rights. In a bigger picture sense, if you get a water right removed from, say, the 2020 list, but then don't use it again by 2030, that's probably going to make it, I would say that probably makes it more likely that you're going to actually see that on the next list. Leasing the water right to others or selling or attempting to sell the water right is another way that you can demonstrate that there's no intent to abandon the water right. Financial and legal obstacles that prevent you from using the water right also is another way to rebut that presumption. The caution here is that the case, the strongest case decided by the Supreme Court on that point, the financial obstacles involved were the Great Depression and World War II. So it's probably not just kind of garden variety financial obstacles, but something more larger and more structural. Use of a water right at an undecreed point of diversion or for an undecreed purpose not only is evidence of it tend to use the water right. So the mere fact that there may be some some discrepancy between what the decree provides and the way you're using the water right isn't fatal on demonstrating your intent to continue the right. But that comes with a point of caution that if you're obviously making an argument that you were using the water right at a undecreed point is going to draw attention to that fact to the division engineer, and so they're probably going to require you to fix that discrepancy and start and use the water right in accordance with its decree. And then there's kind of a catch-all, which again, once you get to the point of justifying non-use, then it's a more narrative argument, and it's what is the story, basically what evidence can you show that you actually intended to make use of the water. And as I said earlier, it's not a subjective test of just saying what your intent was. It's what can you actually demonstrate. And there is a relatively recent case where the Colorado Supreme Court found that the efforts made by somebody to preserve their water right weren't intended to actually make use of the water right. It was just that they were going through the motions to try to avoid abandonment, and the court determined that those efforts were just superficial and not actually evidence of the owner's intent. Few big picture on this, I would say communicate with the water commissioner if you were unable to use the water for periods of time. Again, communicating with the water commissioner so that they are aware of the reasons and the efforts to remedy that. And that is, it's always going to be, I believe, easier if the water commissioner is just generally aware of what you are doing with the water right than if you try to come in early 2030 and then hit them with all of these explanations. Even if you are able to get it removed, that's probably not going to keep a water right off of the list. And then you have to go through all of the objection or protest procedures. Keep records. Just keep a file that you put all of copies of all of the money that you spend in furthering the use of the water right. And I mean, it can be reductive, but spending money is a clear indication of some level of intent. And so making sure that you just have all of those records. So if the water right does show up on one of the lists, you have that and aren't going back trying to recreate that. And then I would also say have a plan. If you can't use the entirety of the water now, get estimates, have some sort of plan to say by X date you intend to get to the point where the water right can be used in its entirety. Many of the settlements that I was involved with in this last protest round involved agreements that included milestones saying by X date the structures will be repaired so that they are capable of diverting the full right, and by date Y the water will actually be diverted and used. And so the more concrete you can be in that. One, it gives you a better story to talk to the division engineers about whether the water right should end up on the list, but it's also of itself just good demonstration of your continued intent to make use of the water. One other thing I wanted to note, I mentioned earlier that the Division of Water Resources prepared forms for for objecting to that initial list, and I actually think they've done a really good job because most of these justifications are actually dialogue boxes in that form. And so they actually ask, have you leased the water? Have you tried to sell? And so the actual form is a pretty good checklist as to the various types of information that will help prevent a finding of abandonment. I guess as we get close to wrapping up, one of the specific issues that at least I encountered in this last go around involved where there are water rights that have multiple owners. The intent requirement is finding that the owner of the water right intended to abandon. And so legally, that finding of intent needs to be applied to each individual owner, not necessarily collections of owners that may share a water right. And so, as an example, if there's a 10 CFS decree and there are 5 equal owners, each user should be able to maintain their water right by establishing that they used their 2 CFS. And so if not everybody's using the water on the same day, you don't necessarily have to show that the full 10 CFS was diverted at a single point in time. You just have each owner should be entitled to establish that they used their portion of the water right. And just as a law school type example, if multiple users had a rotational agreement where each used their water right on a different day, you could, in that example, a structure that could only carry 2 CFS, if everybody's taking their 2 CFS on a different day, that should not be evidence that the full 10 CFS isn't being used. There is a case that distinguishes between mutual ditch companies and tenants in common in a ditch. In a mutual ditch company, because the company itself has some ownership of the ditch and the water rights, if the water is being used by a different owner, if the owner of one share of isn't using their water, but that water is being used by another person on the ditch, then in that case, it's the kind of the collectivity of the whole thing allows for the prevention of abandonment on the full amount. But where there's not a mutual ditch, the use by another person on the ditch of a non-user's portion of that won't necessarily prevent that portion from being abandoned. So I think that that gets us to the end of what I had prepared. If we want to move into questions, and I can.
Well, David, thanks. Yeah, anytime we can get a lawyer and the meter's not running, we're going to ask him some questions. So We've got a few. I have some too, but we'll go through the folks that have already posted them here first. So the first one is a common misconception in Colorado. I own a water right, but you're saying that I don't own the water. So the public, all citizens own the water, but I can own a private water right. How does that work, especially on the real estate side where you have a deed that refers to that water right?
Right. It is a little bit of a hybrid that a water right is a property right that can be and is conveyed as real property. But again, it's that usufructuary nature. It is the waters of the state are owned and dedicated to the people collectively, and it's that uh, you just you have a right to the use of the water, but it's not like land or real property where you have no obligation to make use of your empty field or what have you. Um, the the state uh, the state has the right to impose these conditions on the use of the water, notwithstanding the fact that that right is a property right.
Okay. So I don't know if you can see the text in the chat, but the next one is this is seems like a common problem. We hear about it. I hear about it all the time around this issue of you've got multiple users on a ditch. You've got one person that's been maintaining the ditch. Nobody else wants to be involved, and then suddenly you've got a new owner and they have different ideas. And so they cut into the irrigation ditch and they don't really communicate with anybody. There's some water here, so I'll just divert it. So what I'm sure you deal with these cases. What do you do when you got one owner is now trying to redirect the ditches and make others pay for this consolidation? How do you advise folks that come to you with that issue?
there there is a statute that allows for the first part of this where it's just one person that's been maintaining um, and operating the ditch, that there is a statute that allows for somebody maintaining a common ditch to uh, to do the work and then actually get reimbursement from the other users on the ditch.
And
As for, go ahead.
is that only true for, let's say, an incorporated ditch system, or is that true with even a informal ditch system where you've got three or four or five people, but they don't have any type of formal structure?
It does apply to both, and actually, it's it I believe it's designed for those informal structures, since the incorporated ditches are going to spell out, certainly mutual ditch companies are going to have um, allowances for payment of assessments that then go towards the maintenance of the full ditch, and are going to allow for liens or withholding of water for people that don't keep current with their assessments. So I believe that statute is for the protection of these uh, more informal arrangements, so that if there is somebody who is taken on the responsibility, the financial or just the physical work responsibility to keep that ditch in operation, that the other people who benefit from that can't just take a free ride.
Okay. Yeah, there's probably more we could unpack on that one, and maybe we'll have time later, but just trying to get through these. One question is, does what you've been discussing only apply to surface water, or is there a groundwater component here?
There's a groundwater component in the sense that that you can get a decreed water right for an underground for groundwater. There general, like, exempt well permits are actually outside of the priority system, so there aren't water rights um, for exempt wells, or the a well permit is not subject to abandonment, but if the well permit is based on an underground water right, then that underlying water right is subject to abandonment. And I think, especially in Division 3, a significant number of the water rights that were listed in 2020 were in fact decreed groundwater rights. And then to the extent that that a well permit is based on that decree, if the underlying water right is terminated, then that could affect the permit.
And you mentioned exempt. The ones you just used as an example in Division 3 down in the Rio Grande, were those non-exempt groundwater rights?
Right.
Okay. Kind of along those same lines, do wells permitted for irrigation that are not in a designated basin require the water use to be reported to the commissioner? It's this person's understanding that wells outside the designated basins do not need to be metered.
I know that Division 1 has specific metering rules, and I confess off the top of my head, I don't recall the extent to which those are covered under the measurement rules in Division 6 that have been adopted. But what I would say is related to the previous question. If there's an underlying water right which is vulnerable to abandonment, then your best option to ensure that doesn't get abandoned is to make sure that you're keeping good records of that, because in the absence of those records, and metering, it's hard to see how you would establish full use of that. And I guess also I would say that the trend seems to be going towards measurement rules. So even if there are areas where the metering is not required now, my own sense is that we will get to a point that is required of everybody.
Yeah, I think that's good advice. And then too, if you're using that well, like if it's a domestic well and it allows you to irrigate just a small amount of acreage, probably a good idea to keep track of that as well, how much you're irrigating and what you're growing, just like you would with surface water. So a question specifically on the Republican River Basin, which has its challenges. Obviously, the Ogallala formation is being depleted year by year. Is there any water available to use, and how do you show an attempt to use? Do you write a letter since the structures are still there, like as in the pumps?
I'll confess I'm less familiar with the specifics of the Republican, but in general, again, attempts to use the water right are evidence of lack of intent to abandon. So again, I would keep the best records that you can of times that the water levels just weren't high enough to actually access that water. And at some point, just as at some point you have to, with a surface diversion, you have to show that the structure is actually capable of diverting the full water right. If you have a well that for a extended or consistent period of time can't actually get water because of the water levels, at some point you may be subject to an argument that in order to maintain that water right, you might need to deepen the well so that you actually have the potential to utilize that.
Okay. As far as shared water rights go, you kind of touched on that a bit. Just to dive into that a little more, let's say you're you have shares of a reservoir company. And this may apply to just, mutual ditch company or a number of other structures as well. But does the individual landowner still need to provide records in terms of what they use out of that? You've got use that example of, if one person doesn't use their share, but you're on a mutual ditch company and others use their share, that doesn't expand their water right, and it doesn't protect the one that's not using it from abandonment. Is that the same story with, reservoir company or any other structure where if you don't keep track of your records as an individual, but you're owning them collectively with a bunch of other people, but if you don't keep track of your own records of diversion and application, that your portion of that could be subject to abandonment?
As if I were a water right owner in that situation, I would keep my, I would make sure that the group collectively is keeping records of what's being diverted from the stream, but then I would also keep the best records that I can of the amount of water that I'm making use of. In that multiple owner example, where there's 10 CFS decreed, if the diversion records the state has show 10 CFS consistently being diverted at the stream, the odds are that's not going to come under suspicion for abandonment. But if one user isn't taking their part, then as I'll say this last go around, at least the initial lists they were listed by water right and not by owner of a portion of the water right, because again, the state, it's not generally the state's job to track ownership of water rights. And so if there's a shortage in terms of what's being diverted versus what's decreed, and I was a user on that ditch, making sure I was using my full 2 CFS in the example, I would want to keep those separate records so that if abandonment came up and if it were determined that a portion of that water right had been abandoned, I'd want to be in a position to say, well, it's not my portion, it's the other users, and that the water courts do have the authority under those new court rules for abandonment to make those sorts of ownership determinations if they believe that it's necessary to make these kind of determinations.
Okay. Tying into that, then the second part of that question is, well, what do you do if, let's say it's in this case, a reservoir company or a mutual ditch, you've got shared water rights with others, and you don't think that whoever's in charge of it is keeping accurate records, or they're not measuring the water properly, or they're not keeping records even if they are. What should you do? Is that contacting the division engineer, your water commissioner? Is it just getting together with a group of them and trying to resolve it before you do that?
I would probably start with that last item, that working through the corporate structure of the ditch or reservoir company is probably the best way to work an issue like that out. Whether it's, the hope is that you would hope that a majority of the shareholders would want good governance, that if you needed to make a change in procedures or the people implementing those, that you would potentially have the ability to do so. But if that fails, then at the least you've, again, like the previous question, make sure that you're keeping your records up to date, and then I'm sometimes hesitant to bring those sorts of problems to the attention of state officials, because sometimes that can that can bring maybe attention that you don't necessarily want or focus on it. But if that was the only way to if that was the only way to address that, I would probably consider it.
Okay. Switch gears over to development. We've got a lot of developers that, one way or another, they've got to come up with water for their development. So let's say in the course of getting a special use permit, they make a commitment to not use a water right that is associated with, let's say, a piece of ag land that they purchased. That's kind of interesting. We hear, at times those water rights get transferred through water court to the city, to the municipal water provider. But this is kind of a different flavor of that, where the water right holder, in this case, the developer, is saying, okay, I'm not going to ever use that water right again. So they are effectively through that statement of commitment, abandoning that water right, correct?
I think so. The water rights are valuable, and so rightfully people's initial reaction is to oppose or contest abandonment. In that scenario you're describing, where somebody has agreed that they won't divert that right, at that point, at least I'd probably have if I were advising that person, I would probably have a frank conversation as to, in that scenario, then what is the value of trying to preserve that additional portion as a water right versus allowing it to be abandoned.
Okay. And Carolyn, I'm going to get to your question last, but jumping down to Kathy's question. So this is an interesting one, where you've got a mutual ditch, and so you have a lot of shareholders, and you have some shareholders that have subdivided their land. And what they did was they kind of pulled an interesting trick. They conveyed through the ownership change some of the water shares that were associated with that larger portion, but then they kept some back, even though that wasn't allowed by the ditch company. But they did it anyway, and nobody was aware of it until later. And so you've got these landowners that don't own the land, but held part of the shares that were associated with that land that they sold, and they're still holding on to this. They've got an agreement that says I still own these shares, but that's not allowed by the bylaws of the ditch company. So what do you do? How does the ditch company, get those shares back, or did the ditch company ever lose those shares?
So that's a good question. It's a little outside the scope of the abandonment question, and ultimately, I think it would come down to the way the bylaws are drafted, and whether there is a requirement. Certainly, if the bylaws require that water be transferred with the land or be associated with specific land that can benefit from the water, then that sort of transaction sounds like it would violate those bylaws. The mutual ditch companies are I mean, the advantage of a mutual ditch company is the idea that if one person isn't using their water right, then that water in the ditch is available to the rest of the users on the ditch. And so I think in a lot of cases where I know of older legacy ditches where people weren't actually using the ditch, but the share certificates were more like a historical document that they would keep, frame on the wall or such. And frequently, the fact that means that there's more water for the rest of the shareholders to use can sometimes sort of make that not a conflict. But to the extent that there are negative consequences from a situation like you're describing, that then that is something that I would look to the corporate documents to determine whether that's prohibited, and if so, then what the remedies are for that.
Okay. Kathy, hopefully that answered your question. Stacy, to your question, so you've got this happens frequently as well. We've seen issues where you've got one group of folks, maybe a family or maybe an individual that's been taking care of the ditch for many years. Maybe it's an incorporated ditch, just a few shareholders, but they refuse to provide the bylaws to the rest of the shareholders. What can you do in that instance?
Shareholders have the right to inspect the records of the company. So that, again, just as a kind of general proclamation, I mean, if the people governing the company or the entity that's running the ditch or reservoir aren't providing that, then it could just require legal action to force them to fulfill their legal obligations.
Yeah, so you might have to get somebody like David involved. Hopefully not, but so last question. We're at 101, so we're going to call this the last one. I'm sure that we could talk for quite a while, but this is a kind of a challenging question that's sort of outside the realm of abandonment. And we all kind of scratch our heads on this. Why does the state allow water rights in one basin to be sold to a user in a different basin, especially with the compact agreements, damage to the flow regime of the river and damage to other water users of the basin? I think, the short answer to that is supply and demand. But do you have any comments on that one?
Just that you're right. What if I'm remembering the kind of the back of the envelope figures, it's that 80% of the water's on the west slope and 80% of the people are on the east. And so that's just kind of a practicality aspect of life in Colorado. Ultimately, and certainly for purposes of abandonment or administration, a trans-basin diversion on the basin of origin is just treated like any other diversion. So it's within the it's within the priority system. It obviously affects the compact, and but in the basin where the water is diverted to, that is treated as kind of found water, as developed water, that therefore you have the right to use sometimes outside of the priorities of the stream that it's introduced into. But that's ultimately just a policy question, and just kind of a reality of the way that this state is set up physically and demographically.
Okay, well, I'll tack on a 1A question to that they're saying, and this is true. It really goes to injury, I guess. In this case, is saying, well, what if I'm getting injured and that could potentially cause part of my water right to be, abandoned, or all of my water right to be abandoned because of that. And it wouldn't necessarily have to be a trans basin. It could be, just anybody that's causing me injury. I think it goes to primarily that issue. But what if that can cause a water right to be partially abandoned for lack of use?
It shouldn't, because again, if water is not available in the stream because it's being diverted upstream by by somebody with a more senior priority, or you have to let the water pass by the head gate because somebody more senior is downstream, then that water is just not available for diversion, and that should prevent any question of abandonment. If that's happening consistently, again, I would communicate with Division of Water Resources personnel to make sure that they understand that the reason that you're not making full use is because there's not actually water legally or physically available to you. But again, that shouldn't give rise to abandonment.
Okay. Well, we could go on, but we're going to need to wrap it up and leave it there. So really appreciate all this timely and useful information you provided today, David. Lots of questions around that, and maybe we'll have to revisit this some time in the future. So just a reminder to everyone that we have recorded today's presentation, and I'm also going to do kind of a highlights document. So if you won't have time to watch the full recording, you'll be able to read the highlights, which will cover kind of the main points that David made. And I'm also going to be posting on agwaternetwork.org the slides that David presented. So that'll all be available, and I'll send out an email when we have the recording and that highlights document ready. So thank you very much for joining us today, and hope you have a great afternoon. Thanks, David.
Thanks, everybody.